proposed by interveners, and the interveners are the Rio Grande chapter of the Sierra Club, the Pueblo Action Alliance, Citizens Care for the Future, the Native American Voters Alliance Education Project, and Amigos Bravos. Again, we will collectively refer to them as the interveners this morning. So we have the division's motion to exclude some evidence related to additional regulatory proposals by the interveners. The motion to exclude the interveners' additional proposed regulatory requirements filed by the New Mexico Oil and Gas Association. A motion to exclude all of the interveners' proposed evidence filed by the Independent Petroleum Association of New Mexico, IPANM. We have a consolidated response from the interveners to those motions and a response filed by Wild Earth Guardians to those motions. We also have a motion filed by APANM to exclude certain portions of the testimony of Kaylee Shoup, who would be testifying for the interveners, a response in opposition from the interveners to that motion, and one distinct matter that was part of the motions to exclude, which related to the testimony of Mr. Zupan. Sorry if I mispronounce names here, please correct me as necessary. Also, a couple of notice of errata that are filed in connection with all of these motion documents. With us this morning, we have the chair of the commission, Madam Chair Adrienne Sandoval. We also have Commissioner Terry Warnell and Commissioner Greg Bloom. Council, I will ask for your appearances just to make sure we have everyone online and capable of being heard, at least via audio. Mr. Ames, I see your video is on right there. Would you kick us off, please?
Good morning, Madam Hearing Officer, Madam Chair, and members of the Commission. My name is Eric Ames. I'm an attorney with the Office of General Counsel, Energy, Minerals, and Natural Resources Department on behalf of the Oil Conservation Division.
All right, thank you, Mr. Ames. Let's see, do we have counsel for Wild Earth Guardians here?
Yes, Madam Hearing Officer, Daniel Timmons on behalf of Wild Earth Guardians.
Thank you. Good morning. Counsel for NMOGA.
Good morning, Madam Hearing Officer Adam Rankin with the law firm of Holland and Hart. Santa Fe office appearing on behalf of the New Mexico Oil and Gas Association.
Good morning. Counsel for IPANM.
Good morning, Madam Hearing Officer and members of the Commission. Andrew Cloutier of the Hinkle Shaner firm on behalf of the Independent Petroleum Association of New Mexico.
Good morning. And Mr. Meiklejohn.
Thank you, Madam Hearing Officer, members of the Commission. Douglas Meiklejohn. I'm an attorney with the New Mexico Environmental Law Center, and I'm appearing here today on behalf of the interveners.
Good morning. We also have Florine Davidson, the Commission's administrator. I know that we have other staff and counsel from EMNRD and Mr. Moander, Chris Moander from the Attorney General's office with us.
Good morning, everybody.
All right, if there is nothing else before we begin. Oh, and I'm sorry, this morning's session is being recorded and transcribed by Paul Baca of Paul Baca Court Reporters. So there will be a transcript made of the session. So let me begin by saying I have read the motions, the responses, and the case law that was cited in the motion and responses. And we can take up the Zupan and Shoup testimony after we have addressed the much larger issue of whether the proposed additional regulatory changes by interveners should be part of our hearing next Wednesday. I'd like to shorten the argument by saying that in my mind, there's really no question that the interveners should be allowed to present testimony in support of the division and guardian's petition, regardless of whether their additional regulatory proposals are considered. Fortunately, the notice of intent to present technical testimony, in my opinion, was quite clear with respect to each of the witnesses that they had testimony to offer in support of the original petition by the division and the guardians, and also testimony in support of their additional proposals. And I don't really need argument on whether they should be allowed to testify at all. In my mind, the notice of intent is perfectly suitable for allowing them to testify in support of the original petition. I also saw that in their response, interveners noted that they were withdrawing that third additional proposal, which would have codified a rebuttable presumption. So we really are focused on the two additional proposals that were offered there. So having read the motions and really wanting to hear from folks just once this morning, what I'd like to do is start off with Mr. Micklejohn and then go to the replies. Commissioners, I will invite your questions after we've heard arguments from each of the parties. So, Mr. Micklejohn, let me ask if you have anything to add or any particular points you would like to stress in your response to the motions.
Thank you, Madam Hearing Officer. The point that we made throughout our written submission and that is important is that both the public notice and the application for rulemaking emphasize the interest of Wild Earth Guardians and the division in making their proposals to protect public health and the environment. And the two amendments that we have proposed are directly addressed to protection of public health and the environment. The first proposal would require source characterization of a release. It's clear that without knowing what the release is and what constituents are in the release, there cannot be adequate measures taken to protect people who might be affected by the release or the environment that might be affected by the release. The second point is that when there is a release, people who are in the area surrounding the release and in the area that may be affected by the release need to be notified about that release. It's a fundamental fairness to those people that they be told that there has been a release so that they can take whatever measures they deem to be appropriate to protect themselves and protect their property. I would also point out that in our written submissions, we addressed the logical outgrowth test for determining whether a proposed amendment to rules that have been proposed should be allowed. It is our position that the amendments that we have proposed are within the logical outgrowth as that has been defined by federal courts. In its response to the motions to strike or exclude evidence, Wild Earth Guardians pointed out that the logical outgrowth test has not been adopted by New Mexico courts, and that in fact, what's been adopted by the New Mexico courts is a test to determine whether the notice that was issued reasonably provided an opportunity for people to be heard on the matters that are in front of the agency. Because our proposed amendments relate directly to protection of public health and the environment, which is a central theme of the rulemaking proceeding, as I said, as announced in the public notice and in the application for rulemaking, our proposed amendments do meet that other test. And we therefore urge that the commission rule that we may be able to present evidence, including testimony, on those proposed amendments. You mentioned, Madam Hearing Officer, the objections to testimony by Joseph Zupan, who's the director of Amigos Bravos, and by Kaylee Shoup. In addition to taking up those points, I would like to address two other points. One has to do with the timing and length of the notice of intent that we filed. I would appreciate the opportunity to be able to address the objections to that were filed, and also to address the objections that were filed to the hyperlinks in Norman Gaum's testimony, which I believe were raised both by the division and by the Independent Petroleum Association. So I would appreciate the opportunity to address those points as well. Thank you, Madam Hearing Officer.
Mr. Micklejohn, let me ask you a question about the hyperlinks in Mr. Gaum's testimony. I tried to follow them as well and came to the same, I believe, broken Dropbox message that I think other folks did. Are those essential to his testimony in support of the original petition, or only in support of the additional proposed regulatory proposals?
Madam Hearing Officer, I believe that they are important for both points. I wouldn't say that they are essential in the sense of making or breaking his testimony as to either. I believe that his testimony will be helpful as to the original proposals and as to the proposed amendments. I think it would be more helpful with those working hyperlinks.
All right, thank you for that. Mr. Ames, would you like to make what is effectively a reply at this point?
Yes, thank you, Madam Hearing Officer. Thank you for the opportunity to reply. The division's position is that the commission should decline to hear Sierra Club's proposed modifications to Part 29 at the June 9th hearing because it both violates the law and would set a bad precedent. Instead, the Sierra Club should file its own petition, and the commission can then publish a notice, a proper notice, and have a hearing at which interested persons have a full and fair opportunity to present testimony and evidence. I'm not going to debate the merits of Sierra Club's proposed modifications. That's appropriate in a hearing. But I do want to emphasize that the law here is clear. The basic principle is procedural due process, which means that interested persons must get notice about a proposed government action and be given an opportunity to be heard before the government takes that action. The legislature has codified this principle in the statute for the commission in the context of rulemaking in Section 23 of the Oil and Gas Act. That statute requires the commission to give reasonable notice of a hearing so that persons having an interest in the subject matter can be heard. The commission codified this requirement in its rules in part 3, and I will not elaborate on what those requirements are, but they're quite detailed, and they're set forth in all of the briefs of the parties filing motions here. It's fairly clear, obviously clear, that Sierra Club's proposed mods do not fall within the scope of the notice published for this hearing. This hearing was noticed for two reasons: to prohibit major and minor releases, and secondly, to conform Section 15 of Part 29 with Part 5, the enforcement rule. Sierra Club's proposal goes well beyond these two rule changes. It changes all the reporting requirements. It requires operators to file forms for all releases. It significantly increases reporting requirements and significantly shortens the deadlines. It requires operators to give notice to all persons within certain distances and within certain times of the release. And it requires OCD to post all of these forms, information, and so forth on its website. None of that is contemplated by the notice. As for the opportunity to be heard, no interested person reading the notice would know that the Sierra Club's proposed modifications would be heard on June 9th. And now it's too late for interested parties to enter their appearance, and it's too late for them to present testimony and evidence. The parties are in exactly the same position now as well. We've already identified our witnesses. We've already filed our testimony and exhibits. There's no time to prepare. Even if we had the time, there's a real question whether we could present those witnesses and that testimony, because we didn't notice any of it in our pre-hearing statements. Now, Mr. Meiklejohn makes a few arguments with respect to these changes. He argues first that the proposed changes to 29 are okay as long as the change is intended to protect public health and the environment. This argument is based on a reference in the notice to protecting public health and the environment. But that reference is read completely out of context. That reference is not a rule change. It's a reference to the Commission's legal authority to adopt a rule change for Part 29. If the Commission could use a reference to its legal authority to consider a proposed modification, there is no limit to what the Commission could consider at a hearing, regardless of what the notice actually concerns with respect to proposed rule changes. Second, Sierra Club argues that the Commission can hear the proposed modifications because they fall within the scope of the original application for rulemaking, the petition itself. This argument makes no sense. The petition doesn't establish the scope of the hearing. Under the law and the Commission's rules, the public notice does. And it's to the public notice that we must refer for the scope of the hearing. And then finally, Mr. Meiklejohn argues that even if the mods are not within the scope of the notice, the Commission can consider them because they are a logical outgrowth of the OCD's very limited proposed changes to Part 29. Now, according to Wild Earth Guardians, logical outgrowth isn't even a thing in New Mexico, so perhaps that's the end of the question. But assuming that Sierra Club is right, that logical outgrowth is a valid doctrine in New Mexico, it certainly doesn't help its position. The proposed modifications fundamentally rewrite Part 29. There are huge changes to the scope of obligations and responsibilities under the rule for both the regulated community and the division. These changes don't fit with within any test of logical outgrowth applied by this commission, for instance, in the produced water rule and in the venting and flaring rule hearings, or any federal court. They don't fall within the range of reasonably foreseeable alternatives to the petition. No person reading the commission's notice could reasonably construe them to fall within the scope of the notice, and no person reading the commission's notice could reasonably contemplate that this commission would consider them at a hearing. The division also believes that if the commission were to consider Sierra Club's proposed amendments on June 9th, it would set a bad precedent. It essentially would mean that a petition by any party for any reason could serve as a basis for another party to enter an appearance at the last minute when pre-hearing statements are due and propose a change to that part or any other part, no matter how extreme, as long as they can somehow cite to some words in the notice that they allege are broad enough to allow them to bring those proposals to the table. The result would be that interested persons would have to enter an appearance in every hearing that even remotely touched on an issue that might affect them because of their fear of what might happen at the last minute. And then the commission would have to provide, I would suggest, additional time for all the parties who filed pre-hearing statements to prepare testimony on all these new proposed modifications that are far outside the scope of the original notice. That's not how it's supposed to work. That's why there's a statutory requirement for reasonable notice, so that the parties, or so that interested persons can know what's going to be considered so they can adequately prepare for the hearing. If any party can come in at the last minute, 1 week before the hearing, and put anything on the table that they can conceivably argue is within the scope, then the notice has no meaning and the process loses its vitality. Now, you did reference a couple other issues, Madam Hearing Officer, with respect to Mr. Zupan's testimony and Mr. Gom's testimony. I'll not present the division's position on those at the moment, but would like to reserve the right to address those as well. Thank you.
Mr. Ames, around Mr. Zupan's testimony, I saw in the response, Mr. Micklejohn pointed to the procedural order. Certainly, we've been together in some proceedings where verbatim or narrative testimony is required of technical witnesses. From the portion of the procedural order that Mr. Micklejohn cited to in his response, it doesn't appear that requirement was entered in this proceeding. Does that change your opposition?
It does not, Madam Hearing Officer. It's true that both Sierra Club and Wild Earth Guardians argue that Mr. Zupan is not required to provide verbatim testimony. We never asked for that. We've never argued that Mr. Zupan has to provide verbatim testimony. What we said is that he has to provide a concise statement in summary or outline form, which is the requirement in the procedural order. Here, we don't even have that. Mr. Zupan is going to testify for an hour. He's going to have two topics: support for OCD's petition and support for Sierra Club's proposed modifications. For the Sierra Club's proposed modifications, the entirety of his testimony or his statement is that the modifications will improve protection of water resources and for residents from impacts of waste from oil and gas activities. It's essentially one sentence, and it's a conclusion. If that's all he's going to say, he only needs a couple minutes, or even a minute would be enough. So the question is, what is he going to testify for an hour? Mr. Zupan's a professional registered engineer in New Mexico. His resume says he has extensive experience with the cleanup and remediation in oil field wastes. But we have no idea what he's going to say. His one brief conclusion tells us nothing. We have no idea how to prepare for cross-examination. That brief statement does not meet the requirements of the rule, of the commission's rule, and doesn't meet the requirements of the procedural order. We are not arguing for verbatim testimony such as OCD itself has presented in this case. That's not the issue. That's a straw man. Both Sierra Club and Wild Earth Guardians refer to this verbatim testimony as an implication. That's an implication they draw and then attack. That's the nature of a straw man. We never said it. We're not saying it now. We're saying that what has been filed for Mr. Zupan is clearly inadequate under the rule and under the order, and that's it.
All right, I will ask for more information from Mr. Micklejohn after we've addressed the central issue this morning about the additional regulatory requirements. All right, let's see, Mr. Timmons. If you would please, what is effectively a reply at this point to the responses filed by Mr. Micklejohn.
Yes, thank you, Madam Hearings Officer, Madam Chair, members of the Commission, Daniel Timmons, again on behalf of Wild Earth Guardians. I just kind of want to back up a little bit. Guardians filed this rulemaking application with OCD because we believe in that proposal, that prohibiting major and minor releases will help protect public health and the environment. Frankly, Sierra Club's participation and these motions put us in a bit of an awkward spot. Our primary objective here is to get this rule passed. And we filed that joint petition and we've worked with industry interveners and with the division on targeted testimony to make the hearing go smoothly, and because we recognize that working together gave us the best chance of getting this important rule passed. So from that perspective, Sierra Club's intervention complicates things. It's inconvenient. But on the other hand, we fundamentally believe in the value of public participation as a matter of principle and as a matter of law. So we really appreciate the hearings officer's recognition that Sierra Club should be allowed to participate and to provide testimony with respect to our petition, our joint proposal. And that's our fundamental purpose for being here today and for filing our motion. But with respect to Sierra Club's proposed modifications, our interests are really broader than this proceeding. And so we're really concerned about the unintended consequences of importing the logical outgrowth test from the federal notice and comment rulemaking procedures to a very different type of formal rulemaking trial tape process that we have here before the commission. And so we think that as a matter of law, the statute, the Oil and Gas Act, requires reasonable notice, and that has to meet due process requirements, providing general notice of the issues to be presented. In this particular case, that distinction might not matter. Applying the logical outgrowth test or a reasonable notice test might get us to the same place. But we want to caution the commission against importing a legal term of art, logical outgrowth, and the giant body of federal case law that comes with that, because that case law has been developed in a very different context. We recognize the concerns of the division and of industry interveners regarding the potential need to develop new witnesses and new testimony to respond to these new modifications. And that's probably a factor that weighs in favor of finding that that is outside the scope of what was presented. But this is not a notice and comment rulemaking proceeding, because this process does allow for at least some type of response to and back and forth with respect to those amendments, those modifications through cross-examination or potentially rebuttal testimony. At the end of the day, Guardians is simply not in a position to take a side with respect to these particular proposed rules, whether or not they should be considered by the commission. I recognize that may sound like a cop-out, but we have an internal conflict between our immediate objective in this proceeding of getting our proposal passed and our long-term interests and objectives in protecting the right of public participation. And here, that's a bit of a balancing act. So we ask that the commission, the hearings officer, apply the proper legal standard and not unnecessarily raise the bar or tie the commission's hands to considering alternative proposals by adopting what we believe to be an inappropriate legal test that came from a different context. Just as a final note, I think that some of the issues that have been raised in the motions, the timing concerns and the ability to provide a time to respond, highlight opportunities, let's say, to improve the OCC's rulemaking processes overall. And they probably warrant consideration as to ways to make future rulemaking proceedings a little better, a little smoother, and ensure that those due process rights are protected and that robust public participation can also be accomplished. And that those two values, those two goals are not at odds, but can both be protected and promoted in future proceedings. So that is Guardian's position here, and I'm happy if you have any questions.
Thank you very much, Mr. Timmons. Mr. Rankin, do you have anything to add by way of reply?
Thank you very much, hearing officer. In discussions with IP&M counsel, Mr. Cloutier, we had discussed allowing him to present first. So I'm happy to allow him to go first, but if you'd like me to present this time, I'm happy to do that as well.
Oh, I'm not, I don't have feelings about that at all. Mr. Cloutier?
Thank you, Madam Hearing Officer. First of all, I appreciate your desire for efficiency, Madam Hearing Officer, and just want to make sure that I can adopt Mr. Ames's argument by this reference and not repeat his points so that we can move along quickly.
Thank you very much.
Okay, thank you. We just want to make sure that the record's clear on that. We definitely join in Mr. Ames' principal point that the language that the interveners are seeking to latch onto in the notice is an invocation or attempt to invoke what the commission's and division's powers are under 72-2-12, and it is not the purpose of the rule. The purpose of the rule was set forth in one sentence. It is very narrow, as Mr. Ames argues. I'd like to talk about the logical outgrowth test and the earthworks case. It's a little bit ironic that we're here. Mr. Michael John in the earthworks case was taking the position that a reference in the public notice to multi-well pits was ambiguous and didn't provide adequate notice. The court there said, well, maybe ambiguous, but all you had to do is look at the proposed rule and there's a definition of it. If any member of industry looked at this proposed rule after reading the notice and was confused, they wouldn't have been. The two purposes were clearly addressed in the proposed rulemaking and nothing else. First, clarifying what I say. I would guess that while releases were heartily discouraged under the formal rules that exist today, it does clarify that releases are illegal. And secondly, the rule clarifies, as the notice states, that the division's powers to impose various forms of penalty apply to violations of the release rule. That's it. In the earthworks case, the court said, go look at the rule if you're confused about what the notice said. Well, the notice and the proposed rule that the division and Wild Earth Guardians put forth are the same. Secondly, the Court of Appeals in the earthworks case said, well, if you're still confused, ask the division. Well, I personally asked Mr. Timmons and Mr. Ames, are there any other amendments contemplated other than what is here? The answer was an unequivocal no from both of them. So under the earthworks case, the Sierra Club et al.'s proposal to amend should fail. The notice did not alert anyone that an operator's reporting responsibilities were going to be materially altered, that the operator was going to have to undertake new duties with respect to releases. All of these changes do not relate to what was in the purpose of the rule. We think the logical outgrowth test, Madam Hearing Officer, is a practical test. Due process, as Mr. Timmons points out, underlines all these notice concerns. Logical outgrowth allows for robust rulemaking and back and forth and improving the rules as drafted. There is one proposal to amend the rules as noticed that I think all of the 4 participants support, which is to make sure that Part 29 is not in conflict with Parts 27 and 28 of the rules. That is a logical outgrowth of the proposed rules. Make sure that there's not an internal conflict among the rules. However, the substantially increased reporting requirements, reducing the reporting period, requiring 24 hours notice to nearby residents or occupants of buildings. None of those things were in the notice. I'd like to conclude. I viewed this case sort of put it on the other shoe on the other foot. What had happened if one of the industry associations here today had worked with a division to propose a narrow rule, and the other industry association came in with a slew of amendments at the last minute? The press would be here, there would be outrage, there would be concern. I don't accuse anyone of bad faith, but I can't help but think of what this would look like if the situation were reversed. And with that, Madam Hearing Officer, I'll stand for any questions and reserve my comments on the specific individual witnesses, as did other counsel.
Thank you very much, Mr. Cloutier. Mr. Rankin?
Thank you very much, Madam Hearing Officer. Madam Chair, may it please the Commission. I'll do my best here, as Mr. Cloutier has done, to distill and avoid duplication of argument here. But as Mr. Cloutier, I will endorse and incorporate, adopt the statements and arguments made today in opposition here to the proposed modifications by OCD Council and IP&M Council. In short, the additional modifications here that have been proposed by interveners are not contemplated by the narrow and limited scope of the proposed rule or in the notice that was provided. Interveners themselves acknowledge that what they seek to inject into this rulemaking are additional issues that were not proposed by the rulemaking application or in the notice that was provided. As Mr. Ames has stated very eloquently and succinctly, this particular rulemaking has a very narrow scope. It's limited to only the 2 issues essentially that were discussed: the prohibition of major and minor releases, and that's essentially it. Interveners' additional proposed modifications would add entirely new requirements that were not contemplated or could not have been contemplated by the proposed rule. Now, interveners say the proposed rule actually does contemplate these additional issues because the broad purpose of Rule 29 and the proposed changes is to protect the environment and health and safety. But if that were simply the test, then there would be no principal basis whatsoever for any party to add additional issues the week before rulemaking that the Commission and other parties would then be forced to address and potentially contest without having the required notice, due process to review the proposed language, the requirements, or the technical or legal bases for these proposed changes. That's a bridge too far, a door too wide, because then any modification would be deemed within the scope of a rulemaking. Any modification, for example, to Rule 29 intended to prevent spills would be allowed through the rulemaking door the last minute, simply because Rule 29 is also intended to prevent spills. That's not the Commission's test. The test is whether the modifications are a logical outgrowth or could be contemplated from the language that the applicants proposed and noticed to the public. The Commission, in its wisdom, understood the delicate balance between having the flexibility to consider additional modifications at the time of the rulemaking and due process requirements for giving the public and diverse stakeholders and the division and regulated entities reasonable notice of a proposed rulemaking. When the division, when the Commission interpreted and applied its statutory mandate to require and provide reasonable notice, it enacted its updated rulemaking on its updated regulations on rulemaking back in 2017. Those regulations require very specific disclosures and advance notice, all of which could easily be avoided for future rulemakings going forward if the Commission adopts interveners in Wild Earth Guardian's conception of the test for reasonable notice. This is important to understand because their approach would allow parties, as Mr. Ames said, essentially to ambush future rulemakings with additional issues that were not noticed or contemplated by the proposed rule and notification. It would allow parties to totally sidestep the Commission's regulations and specific requirements, including the initial determination on whether to proceed with a rulemaking on those issues. It would allow them to avoid the Commission's regulatory requirements to provide the proposed language well in advance of a hearing. It would allow them to avoid the requirement to provide legal and technical bases for the changes in advance of the hearing. And it would prevent the public, the division, and other parties from having a reasonable opportunity and time to review, comment on, and prepare for the proposed, to address the proposed modifications, either with support or opposition or with additional modifications to those proposed additions. It would totally subvert the intent and purpose of the Commission's own regulations. And that would not be a positive outcome for the rulemaking at the Commission, and it would directly contravene the Commission's updated and revised regulations governing rulemaking that have now been in place for more than 4 years. So the Commission's interpretation and application of its reasonable notice mandate under the statute is not new. It's been in place for years, and it's the Commission's own interpretation of its statutory mandate. It's been applied effectively, even just in the last year, at the produced water rulemaking in 2020, in which the Commission excluded a series of proposals and modifications from consideration at that rulemaking because they were outside the scope of the proposed rule and notification. And again, earlier this year at the vetting and clearing rule, in which the Commission considered a motion to exclude evidence and testimony, and denied that motion and allowed the testimony to go forward. Now, I just want to address separately some of the comments made and make the point that the cases cited in the briefing, including the Earthworks case, were issued prior to the Commission's updated rulemaking regulations. So there's no case law addressing the scope of what's permitted under the scope of the Commission's current regulations governing rulemaking. The Commission has adopted, incorporated its own guidance, its own outlook, interpretation of what reasonable notice requires. And here, in Wild Earth Guardian's papers and the intervener papers, they're attempting to tell the Commission how to interpret its own regulations and rules, which I think is inappropriate. The Commission has effectively applied and construed its authority and requirements under the statute, and has used, as Mr. Cloutier has described, this logical outgrowth test as a practical test. And that test has effectively been able to strike a balance between preserving flexibility to consider modifications during a rulemaking and ensuring that the public and all stakeholders, including the division, have actual and reasonable notice in advance. And here that balance can only be achieved by excluding the proposed additional modifications proposed here by the interveners. With only a week before the rulemaking, none of the parties have had a reasonable opportunity to review the legal or technical bases for the proposed additional modifications, which has been compounded by the fact that we have not been provided the underlying data or technical analysis in support of their testimony. So like the modifications that were presented during the 2020 produced water rule, the Commission should that the commission should exclude this testimony and propose modifications because they stray simply too far from the very limited and narrow modifications proposed by OCD and Wild Earth Guardians in this case. So with that, Madam Hearing Officer, I believe that I've addressed all the points that I wanted to emphasize in response to interveners and Wild Earth Guardians papers. But if there are any specific questions, I'd be happy to answer them.
All right. Thank you very much, Mr. Rankin. So commissioners, Madam Chair, would you have questions of any of the council based on their arguments?
Commissioner Warnell or Bloom, do you have any questions for any of the counselors?
I don't have any questions at this time. No, thank you.
I don't have any questions either. Thank you.
I just have one. Let me get to the right place. Okay, and I'll ask each one of you. I guess starting with the OCD, so Mr. Ames, so within the intervener's consolidated response to motions to exclude or strike in section 3B, bottom of page 7, in the last paragraph, it talks about, in number 2, it's understood that amendments proposed by Wild Earth Guardians and the division focus on releases. That interested party would probably expect that changes might be proposed to sections 1915, 29, 10 of the commission's rules because it addresses notice to be given of releases. I guess my question, Mr. Ames, yes or no? Would you probably know that the changes proposed by Sierra Club were, okay, let me restate that. It says in here probably. Would you have probably been able to know or expect these changes that were proposed by Sierra Club based off of the notice that was given to the public? Yes or no? I think you're muted.
Absolutely not.
Thank you. Mr. Timmons, would you probably have been able to expect the changes that Sierra Club proposed based on the legal notice? Yes or no?
You're not going to let me decline to answer this, are you?
You can refuse to answer if you would like.
Honestly, I don't know, Madam Chair.
Okay. I'm sure I'm going out of order here. Sorry. Mr. Cloutier, same question. Would you probably have been able to expect, based on the legal notice, that the changes from Sierra Club were in the note? Same question. I'm mucking up the question at this point. But could
Absolutely.
you have expected?
Absolutely not, Madam Chair. The Sierra Club necessitates technical testimony in favor of their amendments. There was no technical testimony proposed at any point, and nothing in the rules suggested the need.
Right. A simple yes or no would have been fine. Mr. Rankin, same question, yes or no?
No, Madam Chair.
Thank you. Here, let me unmute Mr. Micklejohn. Okay, Mr. Micklejohn, I think you're unmuted. Same question to you. Would you probably have been able to expect these changes based on the legal notice?
Yes, Madam.
Yes or no? Yes, okay.
Madam Chair.
All right. Thank you. Those were my only questions.
All right, thank you, Madam Chair. So again, well, let me just make a few observations. I appreciated Mr. Timmons' caution about not importing all of the logical outgrowth case law from the federal process onto the state process, and that didn't appear to have been done intentionally in any of the New Mexico appellate case law. Having said that, I guess I would just say, as someone who's been involved in rulemaking proceedings for a variety of state agencies in New Mexico for about 35 years, that I've heard conversations among state agency lawyers and certainly heard conversations among assistant attorney generals who represent those boards and commissions, that this is a phrase we use a lot. And I think when it's used in New Mexico, it's referring to the same thing, if you will. What was referred to in one of the cases as a surprise switcheroo. So whether we use the term logical outgrowth or the fancy legal term surprise switcheroo, that was in that EPA case. I frankly prefer Mr. Ames' language, reasonably foreseeable. And I think that's what Madam Chair was just getting to, is having looked at the public notice, would it be reasonable to foresee that these proposed additional regulatory requirements might be added? It's certainly reasonably foreseeable to correct some language or make minor adjustments. I think I have to disagree with Mr. Micklejohn, though. These were not minor adjustments. Looking, for example, at that EPA case, Environmental Integrity Project versus EPA from the DC Circuit in 2005, where an agency's proposed rule was speaking about minimum air velocity to ventilate underground coal mines. The final rule provided instead a maximum air velocity to ventilate coal mines, and that was found to be out of line. So I'm not aware of case law in New Mexico or otherwise that would support the argument by interveners that something as broad as any provision meant to protect public health and the environment would be reasonably foreseeable. I think, although that wasn't the subject of anyone's argument, I think there's another challenge here for interveners, which is there are other sections in the commission's rule, this very same rule, that relate to release notification, that relate to source characterization, and the fact that the commission would try to or allow a party to, if you will, add source characterization and release notification to a section, a different section altogether. I think, again, is not consistent with what might be reasonably foreseeable. Having said that, there's absolutely no prejudice here from prohibiting interveners from bringing their own petition to, in fact, adopt these changes with a process of its own. I was also put in mind of the one example I have in which proposed changes are by parties other than the initial rule proposer are, if you will, incorporated into public notice, which comes much later in the process, and whereby all kinds of changes can then be considered. And that's the triennial review. If any of you, I know Mr. Ames has joined me in that proceeding more than once. That rulemaking process exceeds a year in length. The Surface Water Bureau proposes changes and then invites anyone else who's interested in surface water to make their own proposed changes. And then all of it is publicly noticed, regardless of whether the initiating petitioner agrees with it or not. We hear all of it. But that's a very different process and not the commission's process. So I think if we're going to proceed with a reasonable notice standard for commission rulemaking procedures and a reasonable notice procedure that allows anyone to discern the scope of what the commission will be hearing, that the additional proposals from the interveners cannot be considered as part of this rulemaking. Now, having said that, we have a few other things to consider. As to the timing and length, let me just say, and I'll go to Mr. Micklejohn here first. As to the timing and length, so long as it is relevant to the original petition, I don't find someone's lengthy presentation to be inherently objectionable. I know that point was made by some of the movements, but it doesn't trouble me so long as it's relevant to the petition at hand. Mr. Micklejohn, can we go to Mr. Zupan? And in particular, I had invited Mr. Ames to address Mr. Zupan's his objection, thinking maybe he would withdraw it based on the understanding that verbatim testimony was not required. But he made the point that that what was offered in the intervener's NOI was not really a summary. It was one sentence. I'm wondering if you can say more about Mr. Zupan's testimony.
Thank you, Madam Hearing Officer. The summary that we provided of Mr. Zupan's testimony certainly is not one sentence. It's a little over a page long. We pointed out that he will describe his background, which has included extensive experience with cleanup and remediation of oil field wastes. He has been a consultant to industry. He has been a member of the Texas Risk Reduction Program Technical Guidance Committee. He's a registered engineer in several states, or has been and is currently a registered engineer in New Mexico and Colorado. He also will explain what Amigos Bravos mission is and how the management of the oil and gas industry, and in particular releases of oil and gas wastes, poses a serious threat to New Mexico waters. He will explain why Amigos Bravos supports the petition that was filed by Wild Earth Guardians and the division, and it would, he will point out, it would be a major step toward the effective regulation of the industry and the protection of New Mexico's water resources from impacts of that industry. We also said that he would support, his testimony would support the 3 amendments to the commission rule that were proposed by the interveners. That obviously is irrelevant at this point, and he will not be testifying as to those matters. That will shorten his testimony considerably. I would expect that, just off the top of my head, that his testimony at this point probably would be somewhere around half an hour or so, because a lot of it was to be taken up with the reasons for supporting those 3 amendments proposed by the interveners. And as I said, that's not relevant at this point.
Thank you for that. As to the other council, I don't know that we need to go round robin. I will ask you to speak up if you have anything to add, but my plan at this point would be to invite Mr. Zupan to give whatever testimony he would like to in support of the petition. And in the event you find or hear something you find particularly surprising, for you to make an objection at that time, and we can address it.
Madam Hearing Officer, OCD appreciates that resolution of the issue. We welcome the support of Sierra Club and its witnesses for OCD's petition and testimony in that light. I think it's incumbent on me to point out that even though we appreciate Sierra Club's support and testimony in support of our petition, Mr. Zupan, it's our view that the presentation of Mr. Zupan's anticipated testimony still falls short of what the rule requires. But given that his intent is to support the rule, and that in the belief that he will limit his comments to that point, we will not have any objections.
All right, thank you. Does anyone else need to speak to this point?
Madam Hearing Officer Andrew Cloutier, very briefly, just want to point out that our concern about Mr. Zupan is solely as a technical witness, because there was no basis for, there's no description of technical testimony. His support as a non-technical witness, IPA&M has no objection to.
All right, thank you. Anyone else?
Madam Chair, I just want to second Mr. Cloutier's statement. If you look at the language provided in the summary of testimony and exclude the support for the proposed amendments that they offered, there really is no description of any technical summary of any technical testimony whatsoever. So not knowing what he would say or what technical support he would provide, I think, I just want to point out that that is in conflict with what the procedural order provides and requires. And interveners understood very well what the procedural order required, because they provided a fully in-depth summary of their other technical witness, Mr. Gom, in their subsequent exhibits. So they clearly understood the intent and purpose of the procedural order, requiring them to provide a summary of the technical testimony. And then that summary, it's a rather detailed analysis of his Mr. Gom's testimony, along with charts and data supporting it. So there's a disconnect to some extent between what they've offered here for Mr. Zupan and what they've offered for Mr. Gom. And I just want to articulate that that's a concern under the procedural order.
All right, thank you. Anyone else on that point? Again, I would propose to hear from Mr. Zupan, and in the event you hear, notwithstanding perhaps not full compliance with the procedural order or even the rule, at this point, what I'd like to do is invite Mr. Zupan to speak. And again, if there's something in particular you object to, speak up at that time. Let's move then to Mr. Gom and the hyperlinks. Mr. Micklejohn, would you like to speak to how we're going to proceed there.
Thank you, Madam Hearing Officer. 2 points. One is that we did type the hyperlink address into a browser, and although it took about 5 minutes to type the longest hyperlink into a browser, it did work. So we believe that parties have had access to the information that is provided in that hyperlink. In addition, yesterday, I sent to the other parties a working hyperlink that does not have to be typed into a browser. I am fortunate to have had the assistance of our very valuable paralegal who has much more computer expertise and knowledge than I do. So she was able to make that a working link. And we would be glad to do the same thing if people are having trouble with other hyperlinks as well.
All right, thank you. Mr. Ames, do you have any particular proposals in connection with the hyperlinks?
Thank you, Madam Hearing Examiner. So as long as Mr. Gom's testimony is limited to supporting OCD's proposal, we would not object to Mr. Gom testifying. It's a little confusing, though, as to what he's actually going to say and what his exhibits support are intended to support. Mr. Meiklejohn said that Mr. Gom's testimony and exhibits were in support of both OCD's proposal and Sierra Club's proposed mods. So it's kind of mixed. Mr. Gom's testimony is about 11 pages long. It's based on this Excel workbook that's about 3.9 megs. We didn't get that workbook until 4 days after it was due under the rules. And just yesterday, as Mr. Meiklejohn acknowledged, the Sierra Club sent it again, this time with working hyperlinks, which Mr. Meiklejohn says now actually did work, even though he acknowledged that they hadn't. So here we are, from our perspective, we're 1 week out from this hearing, and we're just getting Mr. Gom's actual testimony exhibits. And procedurally, this just isn't the right way to do it. A party shouldn't be dribbling out its evidence days before a hearing. To the extent that Mr. Gom's testimony goes to Sierra Club's proposed mods, that's not an issue anymore. But to the extent he's going to testify ostensibly on behalf of OCD or in support of OCD's petition, based on this testimony, we still don't know what it is, just days before the hearing. And I think that the commission ought to seriously consider the necessity to protect the integrity of its rules from this kind of practice by excluding his testimony in whole.
Thank you, Mr. Timmons.
I think Guardians is going to sit this one out, if that's okay with the hearings officer. Thank you.
It's fine, thank you. Mr. Cloutier?
Thank you, Madam Hearing Officer. Join in Mr. Ames' comments. I think at this point, with the proceedings restricted, there may not be a whole lot of damage that can be done, but I think it's very poor precedent for technical witnesses to be dribbling out their exhibits almost with half of the scheduling period over. The deadline was the 26th of May, and we got the stuff yesterday.
All right, thank you. And Mr. Rankin, anything to add?
Nothing separate and apart from what Mr. Ames or Mr. Cloutier have discussed. I just haven't had a chance to review the materials, and I don't know in what way it would support this testimony, and I just haven't had a chance to analyze it. So my concern is exactly in how it will be used and in what manner, and of course the precedent for such late submissions. I think it's a concern that it would be permitted at this stage.
All right, thank you, Mr. Rankin. Mr. Micklejohn, I trust completely that I can count on you to have a conversation with Mr. Gom about the difference or to draw a line there between supporting the original petition and supporting the 3 additional proposals. I'm wondering, though, if you have anything to add to the question of what role the workbook would play in that support, and whether it's necessary or whether Mr. Gom can perhaps make his statements without going into the details of the workbook. Do you have anything to add?
Thank you, Madam Hearing Officer. Certainly, Mr. Gom can testify and limit his testimony to supporting the proposal by the division and by Wild Earth Guardians. My view, without having discussed this with him, is that he can provide compelling testimony in favor of that proposal with or without the workbook. I think the testimony would be more compelling with the workbook, but I believe that he can provide, as I said, compelling testimony in favor of that proposed amendment, even without the workbook. And you can count on me to have a conversation with him. I believe that he may be watching this proceeding himself. So if he is, clearly he already understands that he needs to limit his testimony and his evidence to the proposal advanced by Wild Earth Guardians and the division. But we are planning to have a meeting with all of our witnesses on Monday of next week. So we will talk with all of our witnesses about that distinction.
All right, thank you. Commissioners, do you have questions about this? Let me just offer that it is troubling that the rule and the procedural order weren't fully complied with. Having said that, I'm loath to exclude Mr. Gom entirely as a result of that non-compliance, and am more inclined to invite his testimony without delving into the details of a workbook that the other parties didn't have insufficient time to study.
This is Mr. Warnell. Yeah, I'm certainly not in favor of seeing testimony to an Excel spreadsheet, a rather large Excel spreadsheet that apparently few of us have had any opportunity to look at. I'm kind of wondering why we need more supportive testimony, but I have no questions.
All right, thank you. Commissioner Bloom, anything?
Sure. Thank you, hearing officer, Madam Chair. A couple of questions for Mr. Ames. Mr. Ames, I'm sorry, I might not have fully understood you. Did you propose excluding Mr. Gom entirely from the proceedings?
No, sir. Only proposing to limit his testimony to support for the OCD's petition, to the extent that he can do so without making statements that are based on the Excel spreadsheet.
All right, thank you. That was my only question.
Madam Chair?
I don't have any questions. I think, I do have concerns about procedure. I mean, there's procedure in place for a reason, or else we wouldn't have procedures. And so I feel like that's a really important component. But if the testimony is limited to the proposal and excluding the spreadsheet that, there hasn't been adequate time to review, then I'm comfortable with Mr. Guam testifying.
All right, thank you. So let's plan then to invite Mr. Baum's testimony and I know that Mr. Micklejohn already understands the difference between the original petition and the additional proposals. And then if you would instruct Mr. Baum, please, Mr. Micklejohn, to avoid speaking to the workbook.
I will do that, Madam Hearing Officer.
All right, thank you. I believe then we have then just Ms. Shoup's testimony, unless there's something I'm missing. And in that case, Mr. Micklejohn, I will invite a few comments from you. However, this is a much more common issue that we deal with in these hearings, which is a non-technical witness wanting to draw connections that would require technical expertise or background. In your response, you addressed one statement which went to her motivation, if you will, for getting involved, namely a connection she had drawn in her mind between produced water releases and cancer. And I understand your point. It goes to her motivation. That wasn't the only place in her testimony, of course, where she is asserting that connection. So I'm going to, I will ask you to say a few words. However, I see a lot more of this than the other things we've been talking about this morning. And the instruction is always the same. We simply have to ask non-technical witnesses not to offer technical testimony. And to the extent they manage to squeeze it in regardless, the commission will have to disregard it. So my request of you would be to talk with Ms. Stroop about not making a connection she would have to be an oncologist or an epidemiologist in order to make, going through her testimony with an eye to that. But if you'd like to offer something now, please go ahead.
Thank you, Madam Hearing Officer. I would point out two things. One is that that was not her intent when she made that statement. It was, as you point out, her motivation for getting involved with these issues. The other point is that the motion that was filed by the Independent Petroleum Association neither alleged nor demonstrated that her testimony would in any way prejudice that association. And under the Supreme Court's ruling in Martin v. Village of Hot Springs, just showing of prejudice is necessary to exclude a witness from providing testimony. And so unless there is some demonstration during or at the end of the hearing that her testimony has in fact prejudiced the association, our view is that she ought to be able to testify. We understand that if she does testify in a manner that would require technical expertise, that the commission will disregard that because she is not a technical expert and she is not offered as a technical expert.
All right. So I should offer here, Mr. Micklejohn, I don't actually agree. I think the case you cited is inapt. The prejudice to IPA&M is not necessary. And I know it's not a reported case, but I think the opinion in Louisiana Energy Services versus the Water Quality Control Commission includes a much more apt discussion of the role the hearing officer is supposed to play in a proceeding, an administrative proceeding, to try to assure that testimony that comes in fact, is based on experience and education. Is there anything else that anyone would like to add there?
Madam Hearing Officer, it sounds like you understand my motion, and it's very, very limited, not to seeking to exclude Ms. Shoup in her entirety, just concerns about some of the statements and the description and her qualifications. And so I have nothing further to add.
All right, thank you, Mr. Cloutier. Is there anything else that we need to talk about while we are together? Presumably the last time before the hearing next Wednesday.
Madam Hearing Officer, this is Adam Rankin on behalf of NMOGA. I think it's implied by the ruling to exclude the proposed modifications by interveners, but I just want to make clear for the record that we also raised the issue of the exclusion of non-technical testimony that relates to interveners' proposed modifications, and just want to be clear that as a consequence of the decision to exclude those modifications, that their non-technical testimony relating to those issues would also be excluded.
All right, thank you for that requested clarification. I will write up an order and I will make that clear that this relates both to technical and non-technical testimony. And I think, again, I'm not concerned. I think Mr. Meiklejohn understands.
Madam Hearing Officer, this is Douglas Meiklejohn. We do understand that point, and we certainly do not object to that point being made in the order that you write up. There is one other point that I would like to raise, and that is that both in their written submissions and orally today, the division and the two associations have complained about the length of our submission and the timing of our submission. However, they have not cited anything in either the procedural order or the commission rules to indicate that it was inappropriate for us to submit a long notice of intent or that we submitted it at an inappropriate time. And so the use of the words like ambush seems to us to be completely out of line. We complied with the required procedures, and there's been no demonstration that we did not do that.
All right, thank you, Mr. Meiklejohn. Again, I am not troubled by the length of your witness's testimony, so long as you stay within the scope we've been talking about this morning.
Thank you, Madam Hearing Officer. We intend to do that.
Thank you. Is there anything else we can talk about while we are together before next Wednesday?
Madam Hearing Officer, I just want to say for all of the parties who are panelists right now, you should have received emails from, I don't know if they come from me or they come from WebEx, on maybe Wednesday this week for the hearings next week. So please use those links as you can. There is a link in there for a panelist, which puts you in this little bucket. It will help smooth the process out for next time. So those should have come this week. They populate automatically on my calendar. They may populate on yours too. I'm not sure, but they should have come to your inbox on Wednesday.
Madam Chair, do you know whether those links were sent to the people who will be appearing as witnesses?
No, they were not. The plan is to kind of in the similar fashion as we did the waste rule, as the witness has sort of their turn, the host will unmute them.
Thank you.
And Madam Chair, I think we found it helpful as part of the methane rule in January to get folks onto the platform about 15 minutes early just to check their audio and for that matter, their video. I trust the technical hosts for next week will in fact be on the platform at least 15 minutes early.
Yeah, the plan is to probably start at, what, 8:40, around 8:45 to make sure everybody's got time to get on. And also just a reminder for anybody on the line who either knows of people who wish to make a public statement or wish to make a public statement. There is a sign up for that through the commission clerk, Florine Davidson. Her information is in the procedural order. There was also a press release that was sent out with that information. As a reminder, if you sign up ahead of time, you get 3 minutes to speak. If you show up at the hearing, it is 2 minutes to speak, as was dictated in the procedural order. So I would encourage people to sign up with the commission clerk ahead of time.
Thank you for that reminder. Anything else at all before we adjourn this morning? No. Thank you all very much.
Thank you, Madam Hearing Officer.
Bye.
Thank you.
Thanks.
Hearing officer? This
Yes.
is Paul. Can I get just the 3 spellings of the witnesses? We have the 3 spellings